I want you to picture something for me. Just close your eyes and try to picture a staggering, sprawling $46 million mansion sitting right there on the waterfront in Miami.
Oh, wow. Okay, I'm picturing it.
Yeah, and this isn't just any luxury house, right? It actually happens to be Billy Joel's former estate.
Oh, that's wild. That is a serious piece of real estate.
Right. Now, I want you to mentally fill the garage of that estate with a collection of racing Ferraris. And, just for good measure, park a private Falcon jet out on the nearby tarmac.
Casual, just a private jet.
Exactly. So if you had to guess who is buying all of this, your mind probably jumps straight to, I don't know, a tech billionaire.
Mm-hmm.
Or maybe a Wall Street hedge fund manager who shorted the market or something.
Yeah, that would be the logical guess for sure.
But no, the person buying all of this is a doctor. And here is the truly wild part of this whole story, that extravagant lifestyle is being funded by a hidden, highly secretive ecosystem that is built almost entirely on everyday, mundane car wreck lawsuits. So yeah, welcome to the deep dive.
It's a jarring visual when you put all those pieces together like that.
It really is.
Because it forces you to ask, how does a simple fender bender on a Tuesday afternoon end up paying for a literal private jet?
And that is exactly what we are getting into today. We are pulling from this massive, really fascinating investigative series published by Legal Newsline.
Yeah, it's a great piece of reporting.
It really is. And it exposes this exact market operating down in Georgia. So our mission for this deep dive is to unpack the actual mechanics of this system. We want to show you exactly how a minor low-speed crash gets transformed into basically a million-dollar financial commodity.
Because it is a commodity. It's an entire industry.
Right. We're going to look at who is getting phenomenally rich off these everyday accidents, and crucially, why this invisible system is secretly driving up your own car insurance premiums year after year.
Even if you're a perfect driver.
Exactly. Even if you have never been in a crash. So where do we even start with this?
Well, to understand how this operates, we really have to flip our standard understanding of healthcare completely upside down.
Okay, what do you mean?
So in normal life, you get hurt, you go to the doctor, and you hand them your health insurance card, right? It's a straightforward transaction.
Yeah, you pay your copay and you're done.
Exactly. But in this specific ecosystem, there is a coordinated network of personal injury lawyers, specific medical clinics, and Wall Street hedge funds, and they actively bypass standard health insurance.
They just ignore it entirely.
They avoid it entirely. Instead, they utilize what are called medical liens.
Okay, so a lien is essentially, well, it's like a legal IOU, right?
That's a perfect way to put it. It's a legal IOU. By treating patients on a lien basis, these networks can artificially inflate the cost of medical care on paper.
Because there's no insurance company stepping in to instantly negotiate the price down.
Right. There's no one checking the math. So they are quite literally turning human injuries into high-yield, tradable financial investments.
Okay, let's unpack this. Because I know they actually have a documented blueprint for how to do this. This is not some, tinfoil hat conspiracy theory.
No, not at all. It's an active, lucrative business model.
Right. And we're starting with this LinkedIn post, which, by the way, has since been deleted.
Understandably so.
Yeah, I bet. But it was posted by a Georgia attorney named Ali Awad. He goes by the CEO Lawyer Online.
I've seen that.
And in this post, he essentially laid out the exact playbook for escalating a minor traffic crash into a massive legal payout.
And the level of systematization Awad described there is just remarkable.
It's a literal step-by-step guide.
Right. The very first rule he shared in his playbook is to avoid what lawyers call a gap in care.
Okay, a gap in care.
Yeah. He advised telling the client to see a doctor immediately after a crash.
Like that same day.
Exactly. And if they can't do that, they are instructed to at least go to a local pharmacy and buy a bottle of ibuprofen within 2 weeks of the accident.
Just to get a receipt for ibuprofen.
Literally just for the receipt.
How does a $10 bottle of pills help build a $1 million lawsuit? That makes no sense.
Well, it comes down to the mechanics of proving a legal case in court. In any personal injury lawsuit, you have to prove causation.
Okay.
You have to definitively prove that the specific car accident caused the specific injury you are claiming.
Right. Otherwise, the defense will just say, you got hurt doing something else.
Exactly. If you wait 3 or 4 weeks to finally complain to a doctor about lower back pain, a defense attorney is going to tear that apart in a deposition.
They'll ask what else you did that month.
Yep. Did you help a friend? move a heavy couch? Did you play in a weekend softball league? They'll argue the pain came from somewhere else entirely.
Ah, I see. But that 2-week window, even if it's just establishing a paper trail for over-the-counter painkillers,
Yeah,
that locks in the timeline.
you got it. It legally ties the physical pain directly back to the crash.
Man, that is incredibly calculated. You're basically building the foundation of a lawsuit before the bumper on the car is even fixed.
It's all about the paperwork.
And the playbook doesn't stop there either. Awad's post says you then need to get MRIs on absolutely all injured body parts. But the ultimate goal, like the holy grail of this entire strategy, is finding nerve damage.
Right, because once they find nerve damage, the doctor can order what are called radiofrequency ablations, or RFAs for short.
And Awad explicitly stated in his post that prescribing those RFAs annually is what magically turns a standard accident claim into a, and this is a direct quote, a 7-figure case.
Yes. And mechanically speaking, an RFA involves using a specialized needle to send radio waves into specific nerve tissue.
That sounds intense.
It is. It heats up and essentially burns the nerve so it can't send pain signals to the brain anymore.
Oh, wow. So it's a highly invasive sounding, very serious procedure.
Exactly. And that is exactly how it creates such massive legal leverage.
Because it sounds terrifying to a jury.
Precisely. When a plaintiff's lawyer stands in front of a jury and explains that their client's nerves had to literally be burned away just to cope with the pain of this, what was actually a minor fender bender, it creates an enormous emotional impact.
Wow.
Plus, the recurring, highly expensive nature of that medical procedure inflates the overall value of the lawsuit exponentially.
Right, because they do it annually.
Yeah.
But here is the most critical piece of advice they give the patient, which makes all of this possible. They say, do not use your own health insurance.
Right. Never use your own insurance.
Which sounds completely counterintuitive. I mean, if you have good health insurance, why wouldn't you use it?
That doesn't make sense to a normal person.
No. It's like going to a mechanic who tells you not to use your bumper-to-bumper warranty, but instead charges 10 times the price for the replacement parts, sends the bill to a private investor, and then sues the car manufacturer for the inflated amount.
That analogy hits the nail on the head. That is exactly what is happening.
It's wild.
You see, standard health insurance companies have incredibly strict guardrails designed to prevent exactly this kind of inflation.
Right. They don't just hand out blank checks.
No. They utilize peer reviews to determine if a treatment like an RFA is actually medically necessary in the first place. Furthermore, they have pre-negotiated pricing agreements that strictly cap how much a doctor can charge.
So if a clinic tries to run like a $20,000 procedure through a provider like Blue Cross,
the insurance company might respond, actually, our network's agreed rate for this specific billing code is maybe $3,000.
or they might deny it entirely as an unnecessary intervention.
Exactly. And that kind of oversight instantly destroys the inflated medical bills the lawyers need to walk into a courtroom and ask a jury for $1 million.
Okay, but a doctor still has payroll to meet, right?
Yeah.
The clinic has to keep the lights on and pay the administrative staff.
Right.
So if standard insurance isn't paying these massive inflated medical bills, and the patient obviously isn't paying out of pocket, how are these clinics surviving? They can't just operate on a stack of IOUs and wait 3 years for a trial to settle.
Well, that's the thing. They aren't waiting at all. They are treating these medical liens, these IOUs, as financial assets and selling them off immediately to Wall Street.
Okay, so this brings us to the shadow funders, the third-party litigation funding companies.
Yes. The mechanism works like this. The doctor treats the patient, and the patient signs a lien promising to pay the doctor out of whatever settlement they eventually win.
Oh, okay.
But the doctor wants cash liquidity today, so the doctor turns around and sells that patient's medical debt to a funding company at a pre-negotiated, very steep discount.
Okay, let me just play devil's advocate here for a second. Isn't litigation funding sometimes a good thing? Like if I'm dead broke and I get hit by a commercial delivery truck, I might really need a funder to help me afford rent or medical care while I try to fight a massive, well-funded insurance company in court.
Right, and you're highlighting consumer legal funding there, which does exist to help plaintiffs survive during a long trial.
Okay, so that's different.
It's a completely different beast. The medical legal ecosystem isn't about giving a plaintiff a small advance for groceries. This is about institutional investors buying up bulk medical debt to artificially prop up the settlement value.
Ah, okay.
Let's look at the bankruptcy records for a firm called Infinity Capital, which was a major funder operating in Georgia.
Okay, I have those numbers here.
In one transaction, they bought a batch of medical receivables from a clinic called Stat Diagnostics, Infinity paid the clinic $157,000 in cash.
So the clinic is made whole immediately. They get their cash.
Yep. But the gross billing amount, the number that remains on the paperwork, which will eventually be presented to a judge and jury as the true cost of the patient's suffering, was $879,000.
That is insane. So the clinic is perfectly happy getting a quick 157 grand, but the jury is sitting there looking at a spreadsheet thinking the medical care cost nearly $900,000.
And look at who pockets that massive difference.
A funder.
Exactly. That spread of over $700,000 is the funder's potential profit when the case finally settles. It is an incredibly lucrative alternative asset class for Wall Street right now.
I mean, I was reading about Tecumseh Capital, which is a hedge fund that raises money specifically to invest in these litigation laters.
Yeah.
And they were pitching their investors an 8% annual dividend and total returns in the mid-20s. I mean, a recent financial report on one of their funds showed gross profit margins hitting up to 800% per medical receivable.
800%.
So they're essentially treating human injuries the exact same way banks treated bad mortgages back in 2008.
Yes, bundling them up.
Right. Hiding the actual mechanics behind financial products and selling them off to investors for a massive premium. But wait, if the hedge fund holds all the financial risk and they take the lion's share of the profit, aren't these patients basically just being traded like stocks?
That is exactly what's happening.
And wait, doesn't the treating doctor still have to testify in court as an impartial medical witness?
And that right there touches on the core ethical and legal conflict of this entire system.
It has to.
Yes. These patients' injuries are essentially reduced to commodities on a spreadsheet, generating yields for hedge funds. But for this scheme to actually pay out those 800% returns, the treating doctor has to take the stand in a courtroom.
They have to go under oath.
They have to swear an oath, look a jury in the eye, and testify as a medical expert that these highly inflated treatments were absolutely medically necessary.
And that the minor accident was the sole cause of the pain, which means the doctors and the lawyers have to be in absolute lockstep. They can't have any daylight between them or the whole financial instrument collapses.
Yes, and this financial codependency is exactly what creates the incredibly cozy, high-volume relationships between specific medical clinics and personal injury law firms.
They aren't independent at all.
No, they function far more like integrated business partners than independent professional entities.
Okay, here's where it gets really interesting. Because you'd think an operation this lucrative and, frankly, legally delicate would operate in the shadows, right?
You would assume so.
But they aren't even really hiding it. Let's talk about Dr. Amin Oskaway.
Oh, yes.
He's the anesthesiologist who owns Orthosport and Spine, which is a massive chain of over 60 clinics. He's actually the guy who bought the Billy Joel Mansion and the Falcon Jet we talked about at the top of the show.
Right, Dr. O.
Yeah, and there is literally a public Instagram photo of him posing shoulder to shoulder with a personal injury lawyer named Harris Weinstein.
Who refers to himself as the Georgia Pitbull, if I remember correctly.
The Georgia Pitbull, yes. And the captions on those social media posts are what really caught the attention of insurance defense lawyers. They were openly using hashtags like #InjuryMoneyTeam and #CashMoneySharks.
And Weinstein affectionately referred to Oskaway as my boy, #Dr_O.
#CashMoneySharks. I mean, you've got doctors and lawyers bragging on Instagram about turning injuries into revenue streams. But, social media bragging aside, it's the sheer data, the volume of the referrals, that shows you the chilling efficiency of this factory floor.
Because the volume operates on an industrial scale.
Yeah.
Documents obtained during legal discovery show that the national injury firm Morgan & Morgan sent 752 patient referrals to a single clinic, Barber Orthopedics, in just a 2-year period.
752.
And if you zoom out, Barber Orthopedics took in a total of 29,000 lawyer referrals during that time.
29,000. That is unbelievable.
And that sheer volume of lawyer-directed patients generated $238 million in medical bills.
Imagine if you walked into a physical therapist's office to get your shoulder looked at, and because you happen to be wearing, a blue shirt, the front desk secretly coded your file to charge you 20% more for the exact same ice pack in the exact same stretch.
Right.
That's essentially what they're doing to these patients, simply for having a lawyer attached to their name.
And we have hard evidence of exactly that happening. Discovery documents revealed physical therapy providers actively coding patients as high-risk/MVAL.
MVAL.
Right. That acronym stands for Motor Vehicle Accident Lien. Patients flagged with that code were routinely charged 20% more for the exact same treatments as cash or insurance patients.
Wow.
We even have a documented email exchange between Barber Orthopedics and the Witherite Law Group.
Oh, this email is crazy.
The clinic sent the law firm an estimated cost analysis for a recommended surgery on a patient. And a law firm employee replied, quote, "You may proceed."
You may proceed. I mean, if I found out my surgeon needed my lawyer's permission to operate on my spine, I would run out of the building. Most people would.
The conflict of interest is staggering. So how do these clinics keep these referral numbers and these emails secret from juries? Because if a jury sees a law firm authorizing surgery, the whole facade of impartial medical care falls apart instantly.
Well, they attempt to keep it hidden through very complex corporate dodging.
Right.
When defense attorneys or judges issue subpoenas demanding to see the communication records between the doctors and the lawyers, the clinics simply claim they don't have them.
How can they not have them?
They argue that those records are held by independent case management firms that handle their administration.
Ah, okay. The shell game.
Exactly. And a judge actually used that exact phrase.
Really?
Yeah. Let's look at the deposition of a man named Matt Stubblefield.
Oh, this guy.
He was listed as the CEO running a string of these case management firms out of the exact same office suite. Companies with names like Falcon Marketing, Medernix, and Premier Medical Consultants.
Right. When he was finally dragged into a courtroom for a sanctions hearing because his companies were evading discovery requests, his testimony turned into an absolute comedy routine.
Because he claimed under oath that he didn't know who owned the companies he was the CEO of.
Yes. He testified that he had no idea who the owners were. He claimed he was hired by a mysterious man named Diego Garcia.
Which, just coincidentally, is also the name of a remote military island in the Indian Ocean.
Exactly. But Stubblefield couldn't describe what this man looked like or provide any contact information for him.
Unbelievable.
And then the presiding judge, Eric Norris, actually paused the hearing, looked up the current company Stubblefield claimed to be running, Premier Medical Consultants, and informed him that state records showed it had already been legally dissolved.
So Stubblefield had no idea his own company didn't exist anymore.
None at all.
And the judge literally told him, I didn't fall off the turnip truck.
Yeah, the judge was not having it.
But, while the corporate shell games sound like a bad movie script, the reality of this system gets much darker. Which brings us to the Glenda Ochoa saga.
Yes. Glenda Ochoa is a Spanish-speaking woman living in Georgia. She was involved in a car wreck, went to a personal injury lawyer, and that lawyer directed her to Orthosport and Spine for treatment.
Okay.
She quickly racked up about $18,000 in medical bills. But remember, all the legal documents, the financial agreements, and the medical loan she was told to sign were written in English.
And she didn't speak English.
Right. She later testified through a translator that she didn't understand the complex financial instruments she was entering into. She just signed where the clinic staff told her to sign.
And then, bizarrely, her own doctor sued her for the $18,000.
They did. They took her to court. But during that seemingly routine collection lawsuit, defense attorneys for the insurance company saw a rare opening.
Oh, this is the discovery part.
Yes, and the mechanism of this is fascinating from a legal standpoint. In a civil lawsuit, discovery allows both sides to legally demand internal documents, communications, and financial records.
Okay.
The defense realized they could use Glenda's case to force Orthosport and Spine to finally open their books.
Which is exactly what the clinics never want to do.
Exactly, because if that happened, the whole factory floor, the massive referral networks, the inflated legal codes, all of it would be exposed. And that would subject the clinic to heavy legal sanctions.
Right.
So they realized the only way to stop the discovery process was to ensure there was no longer an active lawsuit for the defense to investigate.
So they just pay her to go away.
Yeah.
Orthosport and Spine, the exact same clinic that was aggressively suing Glenda Ochoa for $18,000 in medical debt, suddenly turns around and offers to pay her $100,000.
Yes. But the legal conditions attached to that check were incredibly specific. To get the $100,000, Glenda had to sign a strict non-disclosure agreement, drop her personal injury lawsuit entirely, and formally fire her personal injury lawyer.
Wow.
By legally erasing the underlying lawsuit, the clinic successfully shut down the defense's ability to demand those internal documents.
That is just, oh wow.
Judge Norris was completely bewildered when this arrangement was presented in court. He essentially said, I have a third party suing their patient and then paying that same patient $100,000 to drop a meritorious claim. I'm going to sit back and watch this movie unfold.
That is the ultimate look the other way tax.
Yeah.
100 grand just to make sure nobody gets to look inside your filing cabinet.
Exactly.
But, I mean, this extreme secrecy can only hold up for so long, right?
Yeah.
Defendants and juries are finally starting to see the actual data, and they're pushing back.
Yes, when the curtain is pulled back, the entire narrative breaks down. Take the case of Philip Menier. This started as a very minor rear-end accident. Menier went to the local ER, was prescribed some basic Motrin, and left with a standard $3,800 hospital bill.
Which is a totally normal, expected sequence of events for a minor fender vendor.
It is. But then he retained a lawyer, and the lawyer referred him into this ecosystem, sending him to multiple orthopedists.
Of course.
Suddenly, that initial $3,800 bill ballooned into $247,000 in special damages.
From $3,800 to $247 grand.
Yes. And the legal team sued for nearly $1 million.
Wow.
But this time, the defense refused to settle. They fought hard, and the judge ordered full discovery. During the trial, the jury was shown hard evidence that Menier's law firm, Witherite Law Group, had sent 532 different clients to that specific clinic.
So they finally saw the machinery.
They did. They saw the call logs of the clinic asking the lawyer for permission to run procedures. And once the jury realized they were looking at a manufactured financial product rather than impartial medical care, they completely rejected the plaintiff's narrative.
What was the verdict?
The jury deadlocked. They were torn between giving Menier a mere $10,000 to cover his initial ER visit or giving him absolutely nothing at all.
From $1 million demand down to 10 grand or zero.
Yep.
And it's not just juries catching on. Major corporations who manage massive fleets of vehicles are starting to go on the offensive.
We are seeing major corporate pushback. Uber, for example, is actively filing RICO cases against these networks.
Wait, RICO? Like the mafia statute?
Exactly. Historically, RICO, which is the Racketeer Influenced and Corrupt Organizations Act, was designed to prosecute organizations like the mafia by proving individuals were participating in an ongoing criminal enterprise.
Right.
Uber is now using that exact same legal mechanism against these medical legal networks. They are arguing that these clinics and law firms are operating a coordinated, fraudulent enterprise.
That is fascinating.
And FedEx is fighting back, too. They have a case in New York where a plaintiff in a minor crash supposedly required 120 separate visits for physical therapy, massages, and acupuncture.
120 visits.
All billed out of a single address in New York City.
For a minor crash.
Yes. And because this exposure is becoming public, we are finally seeing real-world legislative action.
Oh, really?
Yeah, places like New York and Florida have recently passed sweeping laws aimed at curbing staged crashes, insurance fraud, and these artificially inflated litigation costs.
And does it actually work?
Well, as a direct result of cracking down on this ecosystem, Florida actually saw auto insurance rates lower for consumers.
Which is huge. So what does this all mean? Why should you, listening to this deep dive right now, care about any of this if you haven't been in a wreck, you aren't part of a lawsuit, and you've never even heard of a medical link?
It's the big question.
Because every time a Wall Street hedge fund manages to make an 800% profit margin on a simple fender bender in your city, the insurance companies do not just eat that financial loss, they pass that inflated cost directly onto you.
Exactly.
This hidden machinery is exactly why your auto insurance premiums go up every single year.
Yeah.
You are unknowingly subsidizing the $46 million mansions and the private jets.
And if we connect this to the broader picture, the fundamental integrity of both our medical and legal systems relies entirely on transparency and objective truth.
Right.
A doctor's primary duty is supposed to be the physical health and healing of the patient. A lawyer's duty is to seek fair, proportionate justice.
Yeah.
But when medical necessity and legal ethics are systematically bypassed in favor of creating a high-yield financial instrument for investors, the trust in those institutions is completely corrupted.
Yep.
And at the end of the day, it's the everyday consumer who is left footing the bill for that corruption.
So just to recap the journey we've taken today. We started with a personal injury lawyer's LinkedIn playbook, detailing exactly how to artificially inflate an injury claim. We followed that money to Wall Street hedge funds who bundle medical lities, like stock portfolios,
Right.
creating a system where doctors literally need a legal permission slip from an attorney just to perform surgery on a patient. And we explored the extreme lengths, From fake CEOs named after military islands to $100,000 hush money payouts, all taken to keep the whole machine running quietly in the background.
It's an entire parallel healthcare system built not on patient wellness, but purely on litigation value.
It truly is. Which leaves us with one final lingering thought for you to ponder long after this deep dive is over.
Well,
If the commodification of human injury is this highly systematized and this wildly profitable for hedge funds in something as mundane as everyday traffic accidents, well, what other areas of our personal health and our daily lives are secretly being securitized, bundled up, and traded on Wall Street without us ever knowing?
it's a scary thought.
The next time you see a doctor or get an x-ray or, even just drive past a luxury mansion in Miami, you might find yourself wondering exactly who is paying for it and how. Thanks for joining us on this deep dive. Stay curious, and we'll catch you next time.